Now, the most obvious concern here relates to double tax treaties. So many states have signed dozens of double tax treaties, and these double tax treaties, they do normally limit the taxing right of the source states, so of the state where you have a permanent establishment, for instance. And now, because of the UTPR, these states suddenly can tax the global profit of a multinational, at least in theory. And this triggers, of course, the question of whether the UTPR is in line with double tax treaty obligations. And our understanding is that it is an obvious infringement of existing double tax treaties, because you tax something that you are not allowed to tax under your signed double tax treaties. And this will cause probably quite a lot of chaos and confusion in several states in the future. But that's not the only issue here at stake. Of course, the UTPR has also an extraterritorial reach. That means that you tax profits which were created abroad, and that could also infringe customary international law, because there is a common understanding at the global level that extraterritorial taxes are prohibited. So if there is not a genuine link to a certain state, you're not allowed to tax such enterprise. And that's an additional issue that is raised by the UTPR. And of course, we can also later discuss further elements such as bilateral investment treaties, etc. So there are various issues here that are triggered by the design of the UTPR. There we have to look at every single state separately, because states know different systems of how they deal with potential conflicts of domestic law and international law. Because what will happen is states will implement, such as Switzerland, for instance, the UTPR through domestic legislation, so through domestic law. And therefore, we have to analyze what happens if there is an infringement between domestic law and international law. And in several states, of course, international law prevails. So in case there is a conflict, you have to apply the double tax treaty, and therefore you're not allowed under domestic law to apply the UTPR. And therefore also a multinational enterprise, of course, can appeal against the UTPR in the future, and states will not be able to enforce the UTPR unless they change their tax treaties. Now, there are a few other countries in which the domestic law prevails. So there are certain systems in which states foresee that the domestic law prevails, and there, of course, the UTPR can be applied. Now, this is a strange result. You will have certain states that are allowed to levy the UTPR, and you have certain states that are not allowed to apply the UTPR. And it will be more beneficial for the states in which you allow the UTPR, although there is a treaty infringement, compared to other states where there is no a possibility to apply the UTPR. So it's not a clear answer, because it depends on each state's systems, but there are definitely a lot of countries in the world where international law obligations prevail, and of course multinational enterprise will try to appeal against the application of the UTPR also in court in these chaos. So in these states. So we will see some chaos, we will see some litigation probably in the future. So that would be an international law contract signed by dozens of countries. And that would mean that, you could state in such a multilateral convention that the provisions in that multilateral convention prevail over any other treaty obligations that exist among the signing parties. Now, the problem with such a multilateral convention are the following. First of all, of course, it's a very complex procedure, right? You have to agree on a concrete wording of an international treaty. And second of all, in many states, these multilateral conventions have to be approved by Parliament. And so you have the insecurity, you have the uncertainty that national parliaments will approve such a multilateral convention. And probably due to these two reasons, so first of all, complex international negotiations, and second of all, approval by national parliaments, the OECD and the inclusive framework avoided such process. If we see in certain countries that a court will state that the UTPR infringes international law obligation, pressure will be huge that the OECD and the inclusive framework come up with a multilateral convention, because a global minimum tax that is not applicable in certain countries does not work, and therefore we need to have a solution either later or now. I would go for now. So we should try to draft the multilateral convention now, and not once it's too late. Once we are in court, once the Supreme Court says that the UTPR infringes international law, I think it would be better to go that path now and not later in order to avoid chaos.